Good afternoon, everyone, and happy 12-12-12. In fact, for those of you in the Central Time Zone, 12-12's coming up. And so we understand if you have to step out to celebrate at that point. So I'm David Glazer. I'm here with Katie Ilton.
Hello.
Steve Beck, who's waving from afar. And we're going to walk you through actually a bunch of things. The 2013 fee schedule, the inpatient hospital rules, and then a bunch of miscellaneous other developments that I think are going to be perhaps even more interesting than some of the fee schedule changes. We'll talk a little bit about a few reports that have come out, some litigation, and then Steve Beck's going to talk about potential implications of the fiscal cliff. It's speculation, but it's kind of scary speculation. As usual, we have very little administrative stuff to deal with. Our next webinar, assuming that the Mayans are wrong, our next webinar will be on January 9th at this time. And Teresa Thompson is going to be speaking about social media and kind of the issues that can come up with the use of social media in the healthcare context. Our agenda for today is, Katie Ilton, and some of you may remember her as Katie Burkhart, but Katie Ilton is going to talk about the hospital conditions of participation and then some changes there that have an impact and some stuff that also changed in the fee schedule. I'll then walk us through changes to the portable x-ray requirements and reports on imaging and ALJ appeals before Steve takes us to the fiscal cliff. There's an interesting theme that runs through the report today, a few things. One of them is that poor Katie got stuck with some of the scut here. That's one theme, which is really unfair. Second theme is that there's a lot of stuff in here that if you had asked me, is this true? I would have said, oh, yes, it's true. And it turns out it wasn't. They are things that I have believed to be the law that are not. And it goes to show you just how hard it is to stay on top of this. So we'll be flagging some of those changes. I think in some cases it's because the government is characterizing something as a change that we would say has always been the law. So with that long preamble, I will turn it over to Katie Ilton, who's going to walk us through the inpatient rule and the fee schedule.
All right. Thank you, David. And actually, the theme of my portion is about, hopefully you will agree that the Obama administration has gotten rid of some of the scut in the Medicare regulations. This is part of an effort that started last year with the administration saying there are a bunch of yucky rules that seem to not really serve much of a purpose and get in people's way. So we're going to try to get rid of some of those. Now, many of you probably have your favorite regulations to hate, as we all do, and David will talk about one of his later. But hopefully you'll find that some of them have actually gone away. Now, this batch of changes was to the hospital conditions of participation. These actually came out and were effective this summer, but we just wanted to highlight. We weren't able to cover them in our most recent webinar, so we just wanted to highlight them here and talk about the important ones. So the first change that's been helpful to hospital systems has been that now, instead of each hospital having to have a governing body, there can just be one governing body that oversees multiple hospitals in a system. So a lot of systems have a parent corporation and they have subs, multiple hospitals underneath. Now CMS says it's okay to say that the parent board is in charge of all of the hospitals. So that's really CMS kind of catching up with the times now. I would note that on the state law scope of things, there may be a requirement still that the actual entity that owns the hospital has to report its governing body. And so you would need to have a board of directors at that level that's in charge. But in many cases, what will happen is that they will name the board of directors based on the parents' board, and they'll have the same boards throughout. So effectively, it's just really one group of people that's overseeing the hospital. Another change that came along with the governing body piece is that now there has to be at least one member of the medical staff that's on the governing body. And that's really CMS's attempt to ensure that in these multiple hospital systems, you have a medical staff member who's ensuring there's communication between the actual medical staff and the people who are in charge at the corporate level. CMS did clarify that where you have multiple medical staffs, because that is still a requirement. Each hospital has to have its own independent medical staff. Where you have a system with multiple hospitals, you can just pick one of those medical staffs from which a member will be on the governing body. You don't have to have one medical staff member from each of the medical staffs on your governing body. So that is hopefully helpful. Along the lines of who is on the medical staff, it has actually always been the case under the conditions of participation that other practitioners who are non-physicians could be a part of the medical staff. But CMS is making that clearer now by reiterating that requirement and just getting the word out that you can have other, like physician extenders, for example, on the medical staff. I'm not sure how much of a effect or how big of a deal this is. I suppose now that those people will allow those non-physician extenders to have a vote on certain medical staff matters, but that's one change on who can be on the medical staff. And CMS has also now said that podiatrists, in addition to DOs and MDs, can be the chief of staff and in charge of the medical staff. All right, getting to orders. And orders is a topic we've covered in a lot of different webinars, and there are lots of rules about orders. And in fact, this was one that has changed now that actually I didn't realize or hadn't thought about before was the case. So it used to be the case under the COPs that only physicians in the hospital can order drugs and biologicals. Now CMS is saying that anyone acting within their state law scope of practice, so NPs, PAs, can actually order the drugs in the hospital. So that's a helpful clarification. I might not have been able to tell you that that was actually the law before this change, but helpful now. Another requirement that used to be in the COPs was that an order had to be dated and timed and authenticated by the person who made the order. Now the rule is that the order still has to be dated, timed, and authenticated, but it can be done by somebody else who's involved in the patient's care, someone else who's part of the patient's team. So that's loosening those stricter requirements about orders. Along the same lines, there is a requirement in the hospital COPs that is still there that says a verbal order has to be dated, timed, and authenticated. It used to be the case that that had to be done within 48 hours from the time the order was made. Now CMS is saying, okay, we're not going to set the time frame. We're going to let the hospital do that, or if state law dictates, which I'd be surprised if it does in many places, you'd have to follow the state law. But the hospital is allowed a little bit more flexibility in setting that time frame. But to be clear, those verbal orders still are required to be authenticated. Now, on the topic of standing orders, it's interesting because it's never been the case that hospitals could not use standing orders. And in fact, there is guidance and there are statements from CMS going way back recognizing that hospitals do use standing orders. What's happened with this new change of rules is that they've actually put that policy of the use of standing orders into the conditions of participation. This is helpful in some ways because you will hear many consultants, and we've had consultants tell our clients, say, you can't use standing orders. They're not real orders. Medicare doesn't allow it. So now we do actually have a rule that makes clear that Medicare is certainly aware of standing orders and in fact permits them. So I think it's helpful in that respect that we now have this new rule, but query whether actually putting this in the rule is helpful from a practical aspect, because now instead of letting hospitals sort of dictate how they do standing orders, we actually have a rule that says how you're supposed to do it. And so you have to have a process for reviewing them, which I'm sure many hospitals already do, but now it's just actually part of the regulation. The standing orders have to be periodically reviewed. And then I think maybe the most onerous piece is the fact that when a physician or another practitioner decides that a patient is going to be subject to a standing order, then you have to date, time, and authenticate that fact in the patient's record. So I'm not sure that was actually happening in the past, and now it's clear that that actually has to be happening. So query whether this change is actually less burdensome than it was before. In the old COPs, under the nursing requirements, hospitals had to make sure that each patient had a specific nursing plan of care and it had to be separate from everything else. Now, CMS catching up with the times, realizing that there are often interdisciplinary care plans used for patients. They will now allow you to put the nursing component of the care into the interdisciplinary care plan and get rid of the need to have two documents if, in fact, that's how the hospital uses or how the hospital writes care plans. Another change that's supposed to help both patients and hospitals out is the option now for hospitals to have a program where patients or their caregivers choose to self-administer certain medications. And that would include both the medication they bring with them to the hospital and then certain hospital-issued medications. Now, of course, with a new rule comes new obligations about the program. You have to obviously make sure that there's a vetting process for determining which patients are going to be appropriate to be self-administering their meds. There has to be something talking about how the hospital is going to make sure that medications are secured properly. There has to be an education piece where the hospital is ensuring that the caregiver and the patient know how to actually administer their meds and they're doing it the right way. The idea here is that once this program is up and going and you've educated the patient, that frees up hospital staff from having to do the administration when maybe it's not necessary. And also the commentary was talking about how this is really aimed at trying to educate patients on medication and compliance with medication plans so as to reduce the readmission rate where readmissions are based on medication errors or just not following the doctor's orders in terms of taking their meds. So that's kind of the story behind that new program. Now, this is hearkening back to what David said earlier about how we are learning things that we didn't know existed. Apparently, in the old COPs, there was a rule that anybody who's not a physician that administers blood transfusions had to have special training. Oh, and also for IVs. But no elaboration or explanation of what that special training is. Now, CMS has gotten rid of that and said, okay, look, just make sure that you're doing blood transfusions and IVs based on what the hospital or what the medical staff requires, and if state law requires anything, that you're doing it in accordance with that. So that little tidbit is now gone. And then finally, this is an important one for critical access hospitals that I will also embarrassingly say I did not, maybe perhaps I didn't think about it before, but in the previous COPs for critical access hospitals, the requirement was that critical access hospitals provide all of their services directly, which meant through their own employees. Now it's the case that critical access hospitals can provide a whole host of services under arrangements. They can contract with an outside entity to provide those services. So I think that's good for critical access hospitals if in fact there is another game in town that would provide lab or radiology that you could use. So that's aimed at being more flexible for those types of providers. Okay, so switching gears from strictly hospitals to what happened in the fee schedule this year. One important tidbit that's been getting a lot of attention and has been since the passage of the Patient Protection Affordable Care Act is the new requirement that's going to be effective next July, that there be a face-to-face encounter with the patient prior to billing for DME. Now, this face-to-face encounter has to happen within the 6 months prior to the order for the DME. That's a change from the proposed rule, which said the face-to-face encounter could happen 90 days before or up to 30 days after the order. So now there's a strict encounter has to be before the order. This is only going to apply to certain DME items, and those items are going to be specified by CMS each year. There's a list. Unfortunately, it's a little unwieldy right now. I don't think that the list is on the CMS website, but I do know it's in the PDF that I've linked on the slide. This list covers things that CMS has said are particularly are subject to fraud or overuse that they think are suspect. I know, for example, it includes things like glucose monitors, infusion pumps, oxygen equipment, things like that. So, and I assume that this list may be subject to change each year, so it's important to keep up to date. So just to make sure we're clear, the physician that makes the order can do the face-to-face encounter, or it could be a physician assistant, a nurse practitioner, or a clinical nurse specialist. So there's some flexibility as to who actually sees the patient. And at the encounter, you have to make sure that the practitioner who's doing the encounter is actually addressing the need for the DME or why it's needed, and assessing the patient for that particular item. So it can't just sort of be, oh, well, so-and-so saw the patient 6 months earlier, we'll count that as the face-to-face. They have to actually address the DME piece in the visit. It's the ordering physician, however, that has to be the one that documents the face-to-face encounter. And documentation is important here because for DME, documentation is explicitly a condition of payment. So if you don't have the right documentation, there's an argument that you shouldn't get paid for the service. And so there are some specific documentation requirements about how the physician has to sign or co-sign the part of the note if he or she isn't the one who does the encounter.
And I'm just going to interject here. There's a trend creeping in here, I think, that we can see, which is more and more explicit documentation requirements. And I'm sure many of you have heard us give our "if it isn't written, it wasn't done" spiel before. And in many cases, that's the law. But we got to be aware of what I guess you could call documentation creep, which is definitely afoot, and this is a good illustration of it.
Right. Now, there will be, I read, a new G-code that will allow the physician to bill for that work of documenting the face-to-face encounter. And that's going to be the G-code I have up on the slide, and that's only for if the physician didn't do the E&M themselves. So like David just mentioned, and I mentioned, these are conditions of payment. So we have to make sure we stick to this. And also the DME supplier who's actually billing for the DME, it might be different than the person who ordered it, has to have access to that documentation so that it can bill.
So Katie, if it wasn't a condition of payment, what would be the alternative? What are the other, what's the difference between a condition of payment and a condition of coverage or a condition of participation?
Well, if it's a condition of participation, there's a pretty strong legal argument that if you did the work, you can still get paid for it. And if you didn't comply with a condition of participation, which is just what you have to do to be involved in the program, your remedy or CMS's remedy against you might be sort of a slap on the wrist, or in the case of a physician, it might be a reassignment violation. But in fact, you could still have a basis for getting the payment. But here, that's not going to be a lot harder of an argument to make. Oh, and I should mention, the face-to-face encounter can be done via telehealth. So that's a helpful option, especially for people who are unable to get out of their homes or away.
All right. Well, I'm going to take the last part. I despite the fact that Katie, together with our newest health law member, Catherine London, have put together a really good appeal letter on this topic, I was so worked up on this next one that I felt the need to jump in here. And so this is a portable X-ray issue. So CMS has changed the rules now so that a non-physician practitioner, that's an NPP, can order portable X-ray. So according to CMS, the problem is that Medicare's conditions of coverage state that all portable X-ray services performed for Medicare beneficiaries have to be ordered by a doctor of medicine or a doctor of osteopathy, and the records have to be properly preserved. And for those of you scoring at home, we've got the citation to the Federal Register. And so they say, hey, look, it's got to be ordered by a physician. And that means you can't have a physician assistant or a nurse practitioner or a midwife ordering portable X-ray, all right? Well, this is in the category of things that if you had asked me, can a NP or PA order portable X-ray, I would have said, of course. So why would I have said of course? Because 42 CFR 41032, which is the regulation that governs diagnostic tests, seems really clear to me. And it says, All diagnostic X-ray tests and lab tests and other tests have to be ordered by a physician who's treating the beneficiary. It sounds a lot like what we just read, right? You need to, it added here, you have to be a treating physician, but it has to be ordered by a physician. But if you skip ahead a couple of paragraphs, you get some text that I'm going to read to you right out of the book here. That's going to be a little different from the quote on the screen, but non-physician practitioners, that is clinical nurse specialists, clinical psychologists, clinical social workers, nurse midwives, nurse practitioners, and physician assistants, who furnish services that would be physician services if furnished by a physician, and who are operating within the scope of their authority under state law and within the scope of their Medicare statutory benefit, may be treated the same as physicians for treating beneficiaries for purposes of this paragraph. So, in other words, in plain English, where you see physician, insert NPP. Well, this text talks about coverage of diagnostic tests. And last time I checked, portable X-ray is a diagnostic test. So this to me seems crystal clear. And if you look at what it says for 41032, it says it applies to all diagnostic X-ray tests. It doesn't say all diagnostic X-ray tests except those that are considered portable X-ray. And in fact, portable X-ray is a diagnostic test under the same section of the Social Security Act. That's the little 1861 S3 you see there. That refers to the law, the statutory basis for coverage. So I think that the CMS analysis here, to be blunt about it, it just sucks. It's wrong. It's completely incorrect. And it results, I believe this is going to be a first in our 7 years of webinars. I don't believe I have ever quoted the Bible, but I'm going to here. Justice shall you pursue, which is Deuteronomy chapter 16, verse 20, I believe. So here's how CMS talked when a new rule comes out, there's a thing called the preamble where CMS describes their thought process, and in it they'll take questions. And some of the questions were things like, well, geez, we thought people could always order these. And they're like, no, because of that condition of coverage. And then people said, well, but everyone would have relied on the regulations you issued, and it should be okay. You shouldn't be recouping any overpayments on this. And the government said, referring to an OIG report, that CMS should recoup payment for portable X-ray identified under the report ordered by limited licensed physicians and NPPs because of the conditions of coverage. And here's the part I love. We'll continue our recoupment efforts in response to the OIG report. However, we've instructed our payment contractors that the ordering of portable X-ray services shouldn't be made a priority for the additional medical review activity beyond claims identified in the OIG audit. In other words, for the people that we've audited already, we're going to keep recouping our money, even though we're issuing this clarification, and we think that this makes more sense. We won't tell people to go looking around for more of these. So if you were unlucky enough to be picked on before, tough luck, and otherwise we're not going to go auditing it. Wow. I mean, I am beyond words here, especially because with the 60-day overpayment rule, if you really had an overpayment here, you'd have to write the money back. You'd have to write a check. I don't think this is an overpayment. I think there's no way on earth this is an overpayment. Now, there's an argument that everything we've talked about here applies to a really narrow universe, and we shouldn't have wasted your time talking about it. So why should you care? Well, there are a few reasons you should. First, this illustrates a really important point in Medicare research, which is that it's difficult. If you had read 41032, you might think you have everything that's relevant on the question of who can order a diagnostic test. Lord knows I did. But it turns out that those conditions of coverage that appeared later are at least arguably relevant. And so just because you found something that seems to answer your question doesn't mean that you found everything that answers your question. I'm kind of a word Nazi as of late, and notice I very consciously stuck rule and policy in there to highlight the difference between regulations and manual guidance. And I want to, this is a gospel I want to preach if we're going to be quoting the Bible. I want to keep emphasizing the need to accurately describe what it is you're looking at. If your Mac pronounces something, it's not a regulation. It's at most a policy, but it really, I would say, is guidance would be the most accurate term. Regulations are only things that are found in the Code of Federal Regulations. Laws are only things that are found in the statutes. And everything else is either a policy or guidance. Okay, the next point is one we've made many, many times, but just because CMS says something doesn't, and they say it with a lot of conviction, doesn't mean they're right. And I want to keep drumming that one in. And then, this is what scares me about where I see health reform going right now, I think we have a major fight on our hands to keep the system fair. To see CMS coming and trying to take money back from our clients because a nurse practitioner ordered a portable x-ray in a skilled nursing facility really inflames me. And to watch them say, yeah, well, it might have been confusing, but tough. It's important to remember that the law says that if a practitioner is without fault, the Medicare program can't recoup an overpayment. And I will bet dollars to donuts that a judge is going to conclude that given the wording of 410.32, a practitioner is without fault for thinking that you can rely on this. Maybe it'll prove that I'm wrong, but I think the odds of winning on that are quite good. But we've got a struggle on our hands. Now, a question we get asked sometimes is, hey, if you want to get new information, changes like this happen, where are we going to learn about it? You might learn it from our webinar, but we only do these monthly. What else can you turn to? So I just want to mention a couple of sources. We do periodic newsletters. We probably aren't as religious about that as we should be. But Orthopedics Today has been kind enough to host a blog that I'm doing on a semi-regular basis. So if you can go to the Orthopedics Today website and check out the blog. In addition, Nina Youngstrom is the editor of Medicare Compliance, the report on Medicare Compliance, and they do a really good job of covering changes in the rules. So those are a couple of places you can look if you're trying to stay on top of stuff. In addition to just getting the email alerts from CMS, which is a great free way of knowing what the heck is going on, we get them and really try to use them. So the blog is one of the places I talked about a new report that came from the GAO. And so this is an interesting one because it's a harbinger of another attempt to regulate imaging. So the GAO did a report entitled Higher Use of Advanced Imaging Services by Providers Who Self-Refer, Costing Medicare Millions. So this study looked at physicians who acquired imaging equipment. And I think the way they did it, if I understood the report properly, it was the methodology description was not the easiest reading in the world. But if I understood it correctly, what they were doing is they took claim forms and said if the ordering physician was the same as the supplying physician, they assumed that there was an ownership relationship there, which, if true, isn't perfectly accurate because, like in a nonprofit clinic, you would have the ordering physician and the supplying physician be the same, but no ownership. So first problem with the methodology. And also, you could have physicians who own an unrelated entity where they wouldn't show up. So, but ignoring all of the methodology things, what they found was that people who switched, which meant that they acquired imaging, they went from sending imaging outside to doing the imaging internally, increased their number of scans by 67%, okay? And they claim in this study that results in 109 million scans that otherwise wouldn't have been ordered. Now, when you see a study like this, the big question is what we're talking about here a causation, or is there merely a correlation? Because I can tell you this, I'm only going to buy a scanner if I order a lot of scans. There's no reason you'd invest in a scanner if you're not a frequent user of scans. And you're most likely to acquire one if you think that you're going to be ordering more of them. So whether or not the acquisition of the scanner is what caused the thing is completely open to question. This is an interesting one in that every study I've seen from the government or from other, like the study that resulted in the Stark report was a study done, I believe, by a guy named Alan Hillman, who was in Pennsylvania, if my memory is right. And he did something very similar, looked at scans done by practitioners who owned equipment and compared just numbers ordered by people who owned to number ordered by people who didn't. That doesn't tell you anything about the medical necessity of the scans. If someone wants to go off and do a real study where they double-blind review scans and say, let's review scans that are ordered by people who own equipment and those who don't and see if a higher percentage of the scans are unnecessary when the people owned, that would be a real study. To the best of my knowledge, that study has not been done. And so it bothers me a lot when you have the conclusions drawn from what I think are really crummy correlative data. But the bottom line in this is you can rest assured that there will be another move to get rid of physician ownership of imaging. So you can see that coming down the pike. The next report I want to talk about is an OIG report. And this is a report on the administrative law judge process. And any of you who have done many appeals would be really, your pulse will quicken at the title. You'll feel a bounce in your step in optimism. Improvements are needed in the ALJ judge level of appeal. The report actually only had one L in level. I managed to put in two because I don't know why. So the first thing I was expecting to see was, boy, takes a long time to get an ALJ decision. I mean, Katie and I are working on an appeal right now out in California, and how long are we on? I think it's over a year, right? So I'm thinking that's what it's going to talk about. But no, you only had to get about 2 paragraphs in for them to say that timeliness isn't a problem anymore. It's improved dramatically since 2006, asserts this report. Apparently inconsistent with any of my actual experience, but all right. It did identify, however, 10 problems that didn't include timeliness, and these are gems. So one of the biggest problems, there are certain clinics or hospitals that appeal a lot of claims. And these appellants are referred to in the report, and I'm not making this up, as frequent flyers. And these frequent flyers file lots of appeals when this is a problem. And the solution proposed in the report is a filing fee to discourage people from appealing claims. Okay? Now, you'd think, of course, that there's going to be evidence that these frequent flyers are filing frivolous appeals, which has lots of Fs. So let's look at the data. So here is the percentage of fully favorable appeals filed by frequent flyers. It gets better. So they were fully favorable on the Part A side 67% of the time if you're a frequent flyer. If you were not a frequent flyer, if you just appealed sometimes, what was your appeal rate or victory rate? Oh, 67%. Exactly the same. So maybe it'll be different for Part B. Oh, no, it turns out that on the Part B side, people who appeal the most win more than people who don't. So that pretty much shows that the appeals by these frequent appellants are frivolous, right? I'm going to say no on that. In fact, and this is one of the things that got my blood pressure up. Again, I'm going to be needing a lot of drugs here. Here's what the GAO said. I'm sorry, this is an OIG report. Wrong government agency. The OIG said, well, practitioners are winning a lot of these appeals. So what does that tell us about the appeals process? It tells us that the ALJs are making bad decisions. They conclude that obviously the quick makes the right call, and so the fact that the ALJs are reversing them this frequently means that the ALJs are making the wrong decisions. And in fact, what they assert is that they're making decisions based on the spirit and not the letter of the law, and that the ALJs are too lenient with new evidence. You probably, if you do these things, know that once you get to the quick level, you have to include all of your evidence at that's the second level of appeal. So the first level of appeal is a request for reconsideration, and then you go to the qualified independent contractor, or quick. And when you get to the quick, you have to include all of your evidence at that level. If you don't, you're barred from using it at the ALJ level unless there's good cause. And the OIG feels that judges are finding good cause too frequently in allowing in evidence. And so they're torqued off by that. So another thing that's bothering the OIG is they say that when an organization is under investigation by the government, they will often appeal a claim up through the ALJ process and win, and then use that win to say, see, we're not doing anything that's wrong. Now, I would say that the OIG is correct. In fact, we have advocated that strategy. I remember first using that strategy in 1995 in a case, and it worked really, really well. And I can see why the OIG doesn't like it, because that was kind of the end of their investigation. They, however, draw a slightly different conclusion from that fact than I do. They say this is a problem and we shouldn't allow organizations that are involved in an investigation to appeal things up through the administrative law judge process. So they want to prohibit that and say that if you are under investigation, you should not be allowed to appeal up the process. Sense a trend here? Another thing the report said is that CMS wins more when CMS or one of its contractors participates in the hearing, which is apparently true. They win when CMS participates, it wins. I think that these are backwards, so I think that the loss rate is only 62% when they don't participate versus 59% when they do. So it's a 3% swing. One of the other things that they're pushing is they want a quality assurance program to review ALJ decisions because they're noticing too many ALJ decisions have a space before their period, and so they want to prevent that from happening again. But then the other thing they note is that there is a wide variation between this is a fact that is that's real and that is worth noting, because if you do lots of appeals, you've probably experienced this. They notice wide variation in the results from judge to judge. And so it's hard to read this probably on the screen, but the stuff that's all black are the actual results from the ALJs. The white boxes are data where they said, okay, we looked at the win rates in the various programs. So Part A, Part B, DMEPOS, Part C, and Part D. And we said if a judge had 30% of his caseload was Part A versus another judge where 40% of her caseload was Part A, and we know what the average win rate in Part A is and Part B, we're going to figure out what the expected number of wins in each court case is. Now, to me, that's flawed to begin with, because why you would assume that the win rate for Part A cases should be consistent, I don't understand. But in any event, that's how they did this, and you will find the lowest awarding judge had about a 19% fully favorable rate. Remember, you can be either fully favorable or partially favorable, and it's worth noting that a partially favorable win can be what you would consider to be fully favorable. And let me give you an example of that. If you have a $3 million appeal based on a statistical sample, and the judge throws out the sample and finds that there is a $10 overpayment on the $3 million case, that result is not fully favorable. It's partially favorable. Now, your $3 million overpayment became a $10 million overpayment, so you're dancing in the streets, and you would consider that a fully favorable decision, but the court doesn't. So when we find numbers here for fully favorable decisions, that massively understates the practical result to people who appealed. But you can see the top judges had rates of close to 90% fully favorable for the appellants. Okay, the last recommendation they made, they want to make the case files electronic. There's one I won't object to. And I will just mention something for those of you who appeal a lot. Keep in mind, it's worth numbering your pages when you send stuff in to the judge. I put this in as a request to me because I sometimes get involved in appeals after it gets to the ALJ level and not before. And working on the record when you don't have page numbers is a bear. So what does all of this mean? Well, we can expect a fight. There's going to be the government is losing a bunch of its appeals because quicks make bad decisions, in my opinion. But they're going to try to stomp out your ability to appeal, and we're going to have to fight this back, and I think people are going to have to pay attention and make sure no one sneaks this stuff through. It also means that if you're doing appeals, you can expect it there to be more likely that the MAC or the RAC shows up at the hearing. So you should be prepared for that. It may mean you're going to want to prepare a little more aggressively. You may want to seriously consider whether you're going to have representation at that hearing if you're doing them on your own. But the appeals are going to get more contested. This is just another reminder, don't trust data. The data in here was drivel. And I want to keep mentioning that because we're clearly moving to a period where quality payments are going to become a big deal. And the quality data is crummy. If when you're dealing with healthcare data, the odds are it sucks. And so you have to just kind of be aware of that. And then the other huge lesson here is appeal because you win. And the final thing I'm going to do before turning it over to Steve is talk about one of these. I have a huge thank you. I think actually we've got at least one and maybe two hospitals on this webinar to whom I owe a thank you note. To them and the American Hospital Association, because they have filed suit to try to get declaratory judgment because of CMS's refusal to allow outpatient payments in cases where the inpatient admission is denied. And so that litigation, which I think was filed in November, it might have been late October. If you want a copy of the complaint, email one of us and we can send it to you. So that complaint is going to proceed. It'll be interesting to see what happens. I'm a little worried about one thing, which is there's a Supreme Court case out there that requires you to exhaust administrative remedies before you can seek declaratory judgment. And I think we can rest assured that the government will try to point to that Supreme Court case to get the suit dismissed. But there may be arguments to undercut or distinguish that Supreme Court case. For those of you who are lawyers, it's called the Illinois Council case that involved nursing homes in Illinois that were suing to challenge. Illinois had a rule for nursing homes, and nursing homes that were challenging the validity of this requirement for surveys, and they wanted to challenge it before they were surveyed, because if you are out of compliance with the conditions of participation, they can revoke your Medicare participation. So they went into court and said, we want to challenge this rule. And what the Supreme Court said is, you can't challenge the rule until Medicare comes in, audits you, and takes action against you. Basically, you have to wait until you're kicked out to challenge the validity of the rule. It's a really scary Supreme Court case that, in my mind, doesn't get the attention it deserves, because it puts us in the healthcare world between a rock and a hard place when the government comes out with a rule that we think is invalid but onerous. There are mechanisms to change it, and so it's out there. That could become part of this litigation. It'll be interesting to see. But I'm really happy to see it's out there. In the continuing theme of things we learned about, they cited a statutory provision that I didn't know about until I read it in this litigation, and it's really interesting. I have to admit, I don't fully understand it yet. I'm going to be studying it more, because I think that this is going to be the basis for challenging a bunch of policies where they limit coverage for stuff. So here's the statutory provision, and it says that no rule, requirement, or other statement of policy, with the exception of national coverage determinations, that either establishes or changes any substantive legal standard, if the substantive legal standard governs either the scope of benefits, the payment for services, or the eligibility of a person or an entity or an organization that either provides or gets services, unless it's found in regulations that have been promulgated by the Secretary. Now, there's a lot of words going on in here. I mean, I find this one hard to read, and it's interesting to think about it. It undercuts an argument I've made in the past. So first of all, so let me give you the bad news. I've often thought that the CMS manuals can give you something, but they can't take it away. That, in essence, Medicare would have the ability to be lenient in its policies and give coverage to something in the manuals. And as I read the statutory provision, I think it calls into question whether, in fact, CMS can extend coverage in a manual that isn't created in a regulation. It's also important to note, though, this is only talking about establishing or changing a legal standard for payment, scope of benefits, and the like. So procedural things aren't necessarily covered by this. It's going to be a benefits and payments kinds of question. But this statutory provision is one I hadn't ever really thought about using before. And so the AHA and their counsel identified it, and I think it's an excellent find. And I think it's something we'll want to talk about. Now, and if you've got an appeal, it's something to think about. Hey, is this properly promulgated in a regulation? If not, we've got a statutory basis to challenge policies that are coming out of various MACs or even out of CMS properly. Now, a rumor that we've heard a fair amount is that in situations, so back up a step. If you have a case where the RAC looks at whether your inpatient stay is valid or not, you have a question. Do you want to appeal? And our advice would be appeal. Katie is putting the finishing touches right now on a really good letter to challenge denials of outpatient or of inpatient admissions. I think that these things are appealable on multiple levels. If you want to listen to our whole short stay webinar, that'll walk you through some of it. But at a minimum, one of the grounds on which you certainly should appeal is, generally speaking, the RAC won't allow payment at the outpatient rate. And I think the law is really clear that you should get payment on the outpatient rate. And so one argument is you could just appeal for the difference between outpatient and inpatient, even if you think the inpatient admission isn't medically necessary. I've heard some rumors that when facilities try to do that, the appeal is being dismissed. I would say a couple of things about that. One is, I think if that's happening, the dismissals aren't valid because you have a grounds for appeal if you are being denied payment and you think you're entitled to payment. So it is illegitimate for the quick to dismiss an appeal like that. If you're worried about that issue, one thing you could do potentially is just appeal the whole thing and then at the administrative law judge level, dismiss acknowledge that you are going to concede on the inpatient admission and just seek the outpatient rate. And there are some Medicare Appeals Council decisions that make that really strong. But the lesson here is appeal your admissions denials. If you want help on that, let me know. Or, you can just call Katie directly. She does. This letter is a great letter, and I think it's going to be really, really successful. So now we're going to turn it over to Steve, who's got some very interesting observations about the fiscal cliff. You should feel free to fire off questions because we'll have time to answer those after Steve is done. Monsieur Beck.
Hi, I'm going to spend only a few minutes with my very interesting observations, and I guess you can judge that. The fiscal cliff is looming. Everybody's reporting on it in the newspapers and talking about it. All the talking heads are talking about the fiscal cliff. And in the healthcare world, we have had a fiscal cliff essentially every year. And in fact, I think some pundits are actually sort of drawing that conclusion today. And the fiscal cliff that we always face, and that we're facing again this year, is that the Medicare update calls for a physician fee schedule update that is in conformity with the sustainable growth rate. And the sustainable growth rate is cobbled together out of a number of sort of growth and inflation and population growth factors. Each year, the Medicare update, if it conformed with the sustainable growth rate requirement, would reduce the physician fee schedule update by a large percentage, and each year it gets a little bit bigger. This year's sustainable growth rate, if it were to actually apply, would cut physician pay for Medicare by about 27%. So that's the biggest we've ever seen. Now, what has always happened is that Congress has stepped in and done what they call the doc fix. That's what all the papers refer to it as. And what it essentially does is extend application of the Medicare update so that the sustainable growth rate rules don't apply. Every year it does it just for a year. And so it just kicks the can down the road. The Obama administration proposed a permanent doc fix so that we would get rid of the sustainable growth rate cap, and that got rejected some time ago. So among the things that are lumped together to constitute the fiscal cliff are a number of things. Sequestration, which was specifically sort of created in that budget crisis last year, but also among them is this Medicare update factor, the doc fix. So as part of the negotiations that are going on, we have not this thing considered separately from every other part of the fiscal cliff, but now a large-scale negotiation about what we're going to do with these required cuts, spending cuts. And the Medicare update is required to be cut by the sustainable growth rate. If we allow ourselves to go over the fiscal cliff, we will have this 27% cut. Now, Medicare and the government and all the legislators presumably do not want to go over the Medicare fiscal cliff and cut the physician pay by 27% because they figure the physicians will say, that's it for me, I'm not going to be participating in Medicare any longer. And they'll lose a great deal of capacity. So they know that that is a problem. But there's another part of this, which is that in the fiscal cliff negotiations, Republicans are negotiating heavily for entitlement reform. And because we don't have very many entitlements that matter now, and the one that faces potentially a big negative in the next few years is Medicare, Republicans are asking for something in the way of Medicare cost reductions beyond presumably what is called for in Obamacare, which is, as you know, is a large cost-cutting bill. So we don't know yet what they will get in exchange for whatever they give in resolving the fiscal cliff thing. If the fiscal cliff, if we go over, it is very possible that no one will compromise a portion of it and fix the Medicare update. So we may be faced with the cut coming into effect. Now, that's happened before, and Congress retroactively did the doc fix in the past. But it might not happen this time. We may have the Medicare update with a cut. The latest thing that I saw suggested with regard to what the Republicans get in the negotiation is a pushing back of the age at which you become eligible for Medicare, which presumably would reduce the eligible population and reduce costs. So that's not simply a provider payment, but it's something else that might be very problematic for the other side, which is interested in expanding coverage, not reducing coverage. Seems like that's a problematic suggestion. My worry is that we have a Medicare cost-cutting issue on the table, and we have a great desire by at least one party to do some cost-cutting and show that they can walk away with something from the negotiation. The other thing that I think is really interesting, and you'll see this in the press, is that when they budget Medicare and all the projections that have been done that show Medicare solvency or insolvency, they include the physician payment under RBRVS as if the sustainable growth rate rules applied. So they understate expenditures pretty substantially when they do that, and I assume that everybody on the Republican side who's very worried about the continuing cost of this entitlement program knows that or will know about it pretty soon. So this is going to be much more interesting than it's ever been before, in my judgment, in terms of how this thing applies.
It sounds like interesting. There might be code for bad.
Could be bad.
So we've got a question, and I think, Katie, you may be the person to answer this one. So this is a question relating to the standing order on the conditions of participation revision. So the question is this only for medications, or can you have standing orders used for procedures? For example, if a patient comes to the emergency room for chest pain, and the emergency room has a standing order to do an EKG, can the nurse do this and bill Medicare? Or if it's done as part of a standing order? Our MAC says that no, you can't have standing orders. You can only have standing orders for medications.
And I think that the MAC is actually wrong, and there are a couple of reasons. First of all, before we even had these changes to the COPs, we can point to a number of places where CMS has talked about the use of standing orders and not just solely with respect to medications. In fact, the OIG, I think, has some good language about standing orders being okay, and that was I'm trying to think it was lab. So the use of standing orders has never before been limited just to medications. Now it's interesting. It's an interesting question because in the new COP rules, the standing order rule is separate from the drugs rule. The drugs rule was changed to say that drugs could now be administered via standing orders, and the imaging rule, interestingly, wasn't changed. But I still think we have a standalone rule that allows for standing orders, and a lot of interpretive history in the past permitting this. So I don't think that whatever the intent was, I don't think it's clear at all that there's any limitation on the standing order piece.
Okay, you'll see if your sense of time is better than mine. Do you remember? We did a webinar on orders. I want to say it was this summer, maybe this spring.
We did a webinar on orders, and I think it might have been in September or July.
But so in any event, all of our past webinars are available on the website. And there is one in orders is in the title. And we went into this in more length, and I trust Katie's eye for detail on this one. So if you're interested in that, you can always check that and other past webinars out. I think that right now is our only question. So assuming the Mayans are wrong and the world continues, on January 9th, Teresa Thompson will be talking about social media and its impact on healthcare. And otherwise, if you have any questions, you should always feel free to you can email Katie, Steve, or me, or any of our health law colleagues. So thank you so much for participating in this, and have a wonderful 12-12-12. And I hope that you all celebrated properly, and those of you on the West Coast still can. Thanks.